Thank you. I will now call to order the January 26, 2022 Clackamas County Board of Commissioners Land Use Hearing. I will now lead us in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, and liberty for all. Thank you very much. Good morning again on this wonderfully sunny day. Isn't that great outside? And we're inside. So we are holding this meeting virtually. The Zoom link and instructions to participate via Zoom are located at www.clackamas.us/meetings/BCC/land-use. Today we will consider Z0208-21-CP, an application by Northwest Bible Training Center on property approximately 7.7 acres in size and located at 23172 South Blum Road. Doesn't say the town. The application involves a comprehensive plan amendment for an exception to statewide planning goal 3 for the use of the property, including an existing residence and accessory buildings as an addiction recovery farm. The board will make a decision at this hearing today. Today is a continuation of the December 8, 2021 hearing. At that hearing, technical difficulties prevented some individuals from testifying. This board voted at that time to continue the hearing to allow those that did not have an opportunity to testify to be able to do so today. Those wishing to testify this morning and that did not testify at the December 8 hearing will be called on to provide your testimony at the appropriate time. When you are called on, be sure to include your name and area where you live. New testimony will not be considered at today's hearing. I would like to remind all participants, including staff, all elected officials, and members of the public that Robert's Rules of Order will be enforced in this meeting. We welcome your opinions and look forward to your polite participation. Before I provide a summary of how the hearing will proceed today, I will note that Commissioner Schrader was unable to attend the December 8 hearing. I understand that you have reviewed the recording of the hearing and the materials that have been submitted into the record and intend to participate in today's hearing and the decision on this matter, correct?
Yes, that is correct, Chair. Thank you.
Thank you. We have 4 commissioners sitting at this hearing today. Commissioner Stavis is excused. The hearing will proceed as follows. Number 1, we will hear a short presentation from Senior Planner Melissa Ahrens to summarize the new materials that have been submitted since the last hearing and to provide staff's recommendation. Next, I will open the hearing for public testimony, beginning with the applicant, who will have up to 5 minutes to present to us any new information they would like us to consider. Finally, eligible individuals wishing to testify will have 3 minutes each. And depending on the number of people testifying, I could limit the time involved so this board has enough time to discuss this request fully and render a decision by 11:30 today. Assisting us in the hearing today is our Chief Clerk, Shannon Bays, Planner Martha Fritzie and Melissa Ahrens, and Assistant County Counsel, Nate Boderman. We will now begin the hearing with a statement by Nate Boderman.
I am bringing them into the room now, Chair.
Thank you.
Good morning, Chair Smith, Commissioners. Good to see you. I assume you can all hear me okay?
Yes, we can. Thank you, Nate.
Great. So now is the time set for the public hearing related to the previously identified comprehensive plan application. Now, for those that attended the hearing the first time, I need to go ahead and read some state statutorily required disclosures, so bear with me here. This is a quasi-judicial land use hearing, which means a couple important things for those that wish to participate here today. First, all the criteria that can be used in reaching a decision have been identified in the staff report. So testimonies, arguments, and evidence must be directed towards the criteria identified in the staff report or other relevant criteria found in the comprehensive plan or other land use regulations that people believe may apply to this decision. So anyone testifying is asked to please direct your testimony here today to a relevant approval criterion. Second, failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker, the Board of County Commissioners in this case, and other parties an opportunity to respond to the issue may preclude appeal to the Oregon Land Use Board of Appeals on that particular issue. Likewise, failure of the applicant to raise constitutional or other issues relating to proposed conditions of approval with sufficient specificity to allow the local government to respond to the issue precludes an action for damages in circuit court. Once final, these decisions may be appealed to the Oregon Land Use Board of Appeals. So at this time, I'll ask commissioners to disclose any ex parte contacts, bias, or conflicts of interest that you might have. Looking around and seeing none. If anyone wishes to challenge the impartiality of any commissioner, please clearly indicate your intention to do so in any oral testimony that you may provide today. So that concludes the statutorily required disclosures. At this time, I'll turn it over to Melissa Ahrens. I believe she has a short staff summary for you here.
Thank you, Nate. It's more of an update since the last hearing. So on December 8th, we met to talk about staff's recommendation. So just to summarize, staff's recommendation and the Planning Commission's recommendation was denial of the proposed comprehensive plan amendment. That as staff recommendation and findings are included in the packet available online. During the open record period following the December 8th Board of County Commissioners hearing for this land use item, 12 additional comment letters were submitted, 10 were in opposition and 2 were in support. They are included as exhibits in the record. The applicant also submitted additional information included as exhibit 39 in the packet. While staff appreciates the applicant's submittal, the information that was submitted and included does not change staff's recommendation of denial of the proposed comprehensive plan amendment because it still does not meet the requirements of state law and the county's comprehensive plan amendment for approval of a Goal 3 and Goal 14 exception. We concur based on the traffic information submitted in the initial application and submitted in the applicant's additional information packet that a traffic study is not required. And staff's happy to go into more detail about all of that based on commissioners' questions, but we weren't gonna do that here. We're just providing a brief summary. So that concludes staff's comments at this time.
Commissioners, do we have any questions for the staff right at this point? Does the applicant, oh, Commissioner Fisher, go ahead.
Yeah, thank you. So I'm looking at what's online and I see, I might be seeing it wrong, but I see up to exhibit 38 online.
So it should have been updated last night till exhibit 41. We received an additional exhibit late last night at 10 p.m. that was just sent to you this morning via email. That's exhibit 42, I believe, but the packet online should have been updated by the web team yesterday.
We did get something in the email. I think it was 2 more pieces of testimony. Is that right?
Yeah, you should have received yesterday exhibits 40 and 41 via email, but they should have also been updated online by the web team.
So can you say if those emails, what the number of opposition or support was?
Yes, so the number that I cited included all of the exhibits that have come in up into this point. There were 10 in opposition of the proposed comprehensive plan amendment and 2 in support.
Okay.
Okay, so I only see online, I'm just looking on from the packet that's online is what I'm referencing and it goes to exhibit 38. Somehow I remember my brain reading exhibit 39. It may have come through on my email that I would really like to be able to reference them while we are having this hearing. Could somebody email me?
Fritzy would like to speak to this, Commissioner Fisher.
Okay, thank you.
I'm looking at the BCC webpage with today's hearing, and there is another link called Exhibits 29 through 41. It's not in the original packet that you were sent. And I'm sure Melissa can email it to you if you can't.
Why
It's
don't
find
we
it
take
there.
some time? Why don't we take some time that the commissioners can access that if they don't have it already? Let me know when my commissioners are ready to proceed.
If I might offer a little guidance for the
Yes, Janet, go
website. On that page from the Board of County Commissioners agenda, there are 5 links. The first one says agenda, followed by December 8 BCC packet, followed by exhibits 29 through 41. It is listed separately. And so it is the 3rd link, Commissioner Fisher, that you are looking for.
You are a saint, Shannon. I was just looking in the overall packet, so thank you. Now
You're
I will be
welcome.
able to reference easily what I've already read, but thank you so much. Appreciate Chair Smith allowing me this time to get all sorted out.
Oh, sure, no problem. You know, technology is always a challenge under the best circumstances, right? Yeah, okay. So any other questions for commissioners of staff at this time? I would like the petitioners to come forward now. And are they in the room, Shannon? You're on mute, Shannon. Thank you.
Thank you. I do have I have 2 attendees that say NWBTC, a division of Mission Teens. I'm looking at Martha and Melissa.
And do they have names?
They don't have their names. Would the petitioner for the, would the person who's representing the petitioners please raise your Zoom hand so that I can allow you to speak? There we go. Here they are.
I am actually going to allow Les Poole to share for me. He's representing us. So
Could you please state your name and residence for the record? So anybody who speaks, because we don't know who's on first, it's very important that people state your name.
okay, my name's Christopher Prevetti. I'm the director here at Northwest Bible Training Center at 23172 South Bloom Road. Beaver
Okay,
Creek.
Christopher, since I have your attention, you want Les Poole to speak. I know you had an attorney hired. Do you expect him to speak today as well?
He is present and he's here for any questions that you guys have for him. So yes, that I would like him to speak.
Okay, Shannon, set the clock at 5 minutes. Les, are you able to come in?
Yes, can you hear me clearly?
Yes, we can. Les, go ahead. Please state your name, area of residence, and you have 5 minutes.
Thank you, Chair Smith. Les Poole, I actually live in Gladstone, and the applicant's property is in Beaver Creek, as I think everyone knows. I'll be very brief here. I don't want to take 5 minutes. There's a real issue here with Goal 14, and I want to cover that very quickly. The applicant originally applied without a request for exception to Goal 14. And the reason being is that Goal 14 is intended to deter or prevent urban uses, urban sprawl on farmland. And it has been our position from day one that this is a rural use, not an urban use, and that the staff erred in its assessment that it is urban. I think some of the initial confusion began early on, where the staff believed it was a church or some type of a conventional treatment center, possibly even a clinic. It is neither, and I want to make sure that's understood. None of the uses, none of the activities that are taking place there or that are proposed will have any effect or any damage on farmland whatsoever. None of the activities, nothing that they are applying for creates significant impacts, meaning that, as I've stated before, there's really nothing to mitigate. We don't have the typical scenario where an applicant is possibly applying for a winery or a commercial venture, such as a place to hold weddings, where you're going to attract a lot of urbanites, you're going to create impacts, and you're going to be doing something that is contradictory to farming and preserving farmland. I want to assure everyone that these folks moved to that location after a very careful search. They modified their program to become a rural, farm-based entity in response to the myriad of issues that are affecting the ability for anyone to recover in the urban area. I'll just say this: Portland's a mess right now, and these folks were very, very careful about the property they selected and where it was located, and this is truly ideal. The lack of impacts, the lack of reliance on urban services, and frankly, the extremely low number of urbanites that it may attract are further verification that it is an urban a rural use. Now, we have provided considerable amended testimony with respect to a Goal 14 exception. In other words, we have still provided that, as you all know, but we're still in quite a difference of opinion as to what the use is with the staff. A couple of other brief points and I'll wrap up. The question arises, would a denial substantially burden the applicant? The answer is a clear yes. When one considers these exceptions, I, in all my years of experience, have never seen one quite like this, because typically there's much to mitigate. There's a lot of concerns about how it's going to affect the neighborhood or impact farmland. And again, it really isn't doing any of that. I would close with this. An EESE evaluation, a statement of the consequences of allowing or not allowing this are so unique. How does one place the value on a life saved? We've heard repeated testimony in the public hearings that folks had their children back. One lady had gone from a life of drugs and part-time prostitution to being a college graduate working on a master's degree. Repeated testimony from the participants about how endeared they are to the land and to the Northwest Bible Training Center.
Thank you, Les. Your 5 minutes, Les,
So
your 5 minutes are up.
Thank you.
Thank you very much.
Thank you.
Are there any other people for the petitioners who wish to speak at this time? Now is your opportunity. Nate Boderman, County Counsel or staff, I have a couple questions of clarification based on Les Poole's testimony. He claims that there are lack of impacts and your denial is, they disagree with your denial because there is no damage to farmland, no significant impacts to the farm activities out there. Is that a strong enough reason to approve this?
Melissa, do you want to take the question on the urban versus rural? If you have specific questions on the RLUIPA and the substantial burden question.
Well, Nate, he specifically said there are no impacts to farming activities out there. And so he cites in Goal 14 that the county has not established that burden.
Melissa, you want to speak to that?
So I think there's two different questions going on there. It's the RLUIPA question, which is the substantial burden, which I can let Nate address. The new materials for that focus mostly on, it sounds like, the financial burden and the inconvenience of moving their operation. So that's kind of part A. Part B is maybe the rural versus urban. A good place to look for that is staff's findings starting on page 10 of the staff recommendation. We go over case law of kind of what is that distinction between urban versus rural use. In this case, because the type of use that they're doing out there, a treatment facility, it's dependent upon certain services and providers coming there. It's serving a primarily urban population. We don't have evidence on the record demonstrating that they're just serving a rural area, that the people that are part of the program are only coming from that rural area. We don't have that information. So that was a distinction. Nothing new was submitted in the information submitted as Exhibit 39 to provide more clarity on that. It relies on volunteers, staff, service, and essential goods and service providers coming from outside of the rural area. I think there were also some comment letters that support that concern that came in. It's not appropriate for or limited to the needs and requirements of the Beaver Creek rural area. So those are really kind of the crux of that determination for concluding that it's an urban use, which is very difficult to get a clear read from state law. So it's a nuanced determination, and we're working with what we have on the record in our findings to make that call. So
thank you, Melissa. Martha Fritze, you have your hand up.
Yes, thank you. I wanted to add to what Melissa said and maybe add a little bit, remind everybody a little bit of the context of this goal exception. Whether or not you agree that it needs a goal 14 exception, you need to remember that it still does need a goal 3 exception to the agriculture goal. And there are 4 main criteria for the goal exceptions, both the goal 14 and the goal 3. One of those criteria relates to potential impacts and being able to mitigate any potential impacts. So yes, the fact that, we may agree there's not a lot of impacts or they could be mitigated, that addresses one of the 4 criteria that need to be addressed. The other criteria, I think Melissa is saying still, the application still does not meet those. Whether or not you agree it meets that 4th, it needs to meet all 4 to be approved, not just one of the 4.
Thank you. Thank you, Martha. 2 hands are up, but I want to get a point of clarification on the 3 points that Les Poole brought up. Number 2, would denial burden the applicant? He says yes. And then the final, I don't know what this is. He brought up an EESE evaluation. I don't know what that is. I don't know if that's part of the land use process. Can anybody address that? Martha, your mute is on. Nathan, Nate Boderman, what is an EESE evaluation, and is that new information that has been brought forth?
No, that was the criteria associated with the goal exception. That's shorthand acronym for the different considerations that go into whether a reasons exception is appropriate in this case.
And who does that, Nathan?
Well, the staff has provided an evaluation on that, but it's the applicant's burden to prove that they meet those criteria.
Okay, and they have not in
staff's
staff
opinion.
Okay. Commissioner Schrader, your hand is up. There you go.
After reviewing a lot of this too, that there has been formal resistance from our local hamlet CPO. Is that correct, staff? To have this move forward?
We have had many opposition letters from residents of the Beaver Creek area, but the Beaver Creek CPO did not make a formal motion to oppose or deny. They just submitted meeting minutes from their meeting on the application.
So this would be the hamlet then, right? Not the CPO. The CPO, it's not really a CPO anymore, it's a hamlet. So we're talking about the hamlet, right, Mark? Okay. Thank you for that. So they didn't take a formal position, but all the letters we've gotten from those folks have been in opposition. That's
Not-
what I'm,
Not all of them,
But-
but the majority.
majority. Okay, thank you.
And I
Thank-
see the attorney for the Northwest Bible College Training Center has his hand up. And I'm going to allow that because this technology, it's cumbersome. Not everybody's familiar with it. And please state your name and your affiliation, please. Ray, please unmute yourself.
Hello, Madam Chair. My name is Ray Hackey. I'm an attorney with the Pacific Justice Institute. We're a nonprofit organization devoted to defending religious liberty. I'd like to talk to this.
Please be brief. Please be brief.
Okay. Well, to begin with, I'd like to talk to you about a couple points related to RLUPA, the Religious Land Use and Institutionalized Persons Act. First and foremost, RLUPA prohibits any regulation that, and I quote, totally excludes religious assemblies from a jurisdiction. And not only does Goal 3 do that, but the county's own comprehensive plans do that. So both the Goal 3 itself and the comprehensive plan are in direct violation of RLUPA. And the second thing that I need to point out to this organization is that not only has the county substantially burdened it, but there is no compelling interest in doing so. There is no compelling government interest in preserving farmland, even high value farmland for farm use. If you look at both the Guru Nanak cases, Guru Nanak case and International Church of the Foursquare Gospel, both of them make that clear. International Church of the Foursquare Gospel, which relied heavily on Guru Nanak, states that there is that preservation of industrial lands for industrial use does not by itself constitute a compelling interest for purposes of RLUPA. And Oregon law itself reflects that there is no compelling interest in excluding NWBTC from operating at its current location, because the first and foremost thing that among the non-farm uses that are allowed in areas zoned for exclusive farm use is churches. It does not limit the allowance of religious assemblies on land zoned EFU to those that were established long before the counties in which they sit established such zones. It says they may be established in any area zoned for exclusive farm use. So there really is no compelling interest here that justifies substantially burdening the proposed use of NWBTC's property. And finally, with regard to Goal 14, Guru Nanak addresses that. One of the concerns raised there was leapfrog development. And so that seems to be what urbanization is aimed at addressing. And so, basically that can be a convenient excuse to just keep religious assemblies out of areas zoned for exclusive farm use, and that can't happen. And so I strongly recommend that you go and review both Guru Nanak, International Church of the Foursquare Gospel, as they apply to this case. Thank you.
Thank you, Ray. I'm going to have staff address the three issues you bring up. Number one, our Clackamas County's own comprehensive plan is in violation of RLUPA. How do you answer that?
So if the argument is that we have outright prohibited this use anywhere in the county, we would disagree with that.
And what examples do you have to the contrary?
Well, Melissa or Martha could probably point to which zones you could cite this use in.
Not zones, but actual uses. Isn't that what he's referring to?
Well,
Melissa, your hand is up.
Yeah, I would just clarify that when we first looked at this, this question came up. We were trying to get a better sense of what the use was. And the application clearly says it's not a church. And so that wasn't a use that we were looking at. So just to clarify.
So Melissa or Martha, what uses were you evaluating as far as where alternative sites might be eligible, I guess you could say, or where this use might qualify?
Right. There's a whole section in the beginning of the staff recommendation where we discuss that. That's where we make the determination that the closest use comparable to what the applicant's proposing was congregate housing facility based off the definition in the county zoning and development ordinance. Because the applicant stated it wasn't a church in their application materials, they also stated it wasn't a school. It was like a school, but it wasn't a school. So you can read through there. We were looking at congregate housing facility. We also analyzed where that would be allowed in the county's zoning and development ordinance. There are zones where it would be allowed. So we kind of go into great detail about that.
So my question is, if in the application they state they are not a church or a school, how can they apply the RLUBA standard to this goal exception 14?
So we had submitted some analysis because you don't even get to apply, as you suggest, for RLUBA unless you are, exercising religious practice, right? And we agree that the way that they've characterized this particular use, that we see no reason not to characterize it as religious practice. The issue then becomes is once you are under the RLUBA statutes, or you qualify under RLUBA, then you have to prove, the applicant must prove that they've been substantially burdened. And that's where staff and the applicant diverge in terms of our analysis. We don't, in our review of the cases, don't believe that this rises to the level of a substantial burden because there would either be other zones where this could be cited, there would be other opportunities to accommodate this use elsewhere in the county. It doesn't necessarily have to be on high value resource protected farmland.
The second question or statement that Ray Hackey, excuse me, no compelling interest to preserve farmland. How do you address that?
So the no compelling interest, we discussed this at some length at our first hearing, and that part of the analysis is triggered once a substantial burden is proved. And as I just mentioned, we disagree that a substantial burden is even at issue here. And only when substantial burden is proven is it incumbent upon the government to show that there's a substantial interest. In the record, LCDC submitted some testimony on the state's behalf for why protection of farmland is a compelling interest. And so we pointed to that, I guess you could say, in the record to show that if you found that there was a substantial burden at issue, take a look at the state's material because that would be the next step in the analysis. But again, we don't even get to that until we.
Nate, the applicant, I'm moving along, Nate. Thank you for your answer to that. And then, and my last statement here, Les Poole mentioned the case regarding the Foursquare Church. And how does that apply?
Yeah, so we, again, we submitted a memorandum into the record the first time around, and all of the cases that were cited today, we addressed in that memorandum. I guess on the International Foursquare Church, I'd have to refresh my recollection, but my memory was that the issue there was that the use was entirely zoned out of the city. And that factual dispute was substantiated by testimony from realtors, from a former city manager that said, yeah, you can't cite this church anywhere in the city. And based on that finding, they found that their zoning ordinances or their comprehensive plan violated RLUBA, and so they granted an accommodation.
Okay,
again.
Thank you for that. Any quick questions from commissioners? Because I think we have some hands for public testimony. So now, I will now open public testimony on this item, beginning with the applicant. Okay, we did that. Members of the public are allowed to testify for those people who, because of technical difficulties, could not testify last week at the hearing. Shannon, do we have anybody who meets that criteria who is in the chat room who would like to speak?
I would ask at this time that anyone who would like to speak who did not previously provide testimony would raise their hand so that we can get a count of those of you that would like to testify. If you are calling on your phone, you can use #9 to raise your hand. On your computer, it is at the bottom of your screen.
We'll wait for them to come on if there's anybody there. We'll take some time since this is technology and it's not something that's second nature to any of us really on this type of format. Shannon, do you see anybody?
I have no one with their hands raised.
Okay, we're going to continue to allow that for the moment. Just for the moment, I'm going to, while that is open, I'm going to depart from the script and say, commissioners, are there any statements that you would like to make at this time before we render a decision? Commissioner Scholl. You're on
You're
mute.
muted.
Yes, thank you. Chair Smith, I have visited the Northwest Bible Training Center. I found it to be a clean, healthy, positive environment. 2, the Northwest Bible Training Center costs the taxpayer nothing. Compare that to the millions of dollars we spend on addiction recovery and mental health treatment. 3, the location that the center is at now is conducive to a peaceful, tranquil environment that aids in addiction recovery. 4, we have a shortage of addiction recovery personnel and facilities in the county, which Northwest Bible Training Center helps augment. And 5, the Northwest Bible Training Center is a positive, effective partner with our Clackamas County Health Services. So finally, I like to see them continue to operate at their present location. Thank you.
Thank you, Commissioner Scholl. Does any other commissioner wish to make a statement at this time? Commissioner Schrader, your hand is up.
Yes, thank you, Chair Smith. I do agree with Commissioner Scholl that what they're doing for the community is valuable. However, with the interpretation of our land use laws, it is not the appropriate site for that kind of work. It really doesn't meet the Goal 14 or Goal 3 criteria. And because of that, and again, this has nothing to do with, from my perspective, the value of what they do, what they're doing to help people, and how they are managing to supply a much needed service in our community. The problem is it is not the right location for that. And based on Goal 3 and Goal 14, as well as a lot of the notes and actually letters I've read from the Beaver Creek Hamlet folks, I can't support moving forward with this. I would be a no vote on this. So,
Commissioner Fisher.
Thank you, Chair Smith. I just wanted to also agree with Commissioner Scholl that the use being proposed is important. Providing drug addiction, substance use disorder treatment is a tremendous need that we as a commission value and recognize and are working towards creating more capacity. But we're here today for a land use hearing, and we have before us a roadmap that we are to follow. And because of that, I'm not able to support this today. At the end of the last hearing, I had asked for additional information if there was a possible way to thread that needle in regards to agricultural uses being absolutely essential to the treatment. We didn't receive, I've read the materials, I've consulted with staff, we did not receive any new evidence that could allow me to thread that needle in a responsible way as a decision maker here. So I will not be able to support this land use decision, but that does not mean that I don't support the mission, the great work and the efforts that this organization does.
Thank you, Commissioners. Shannon, do we have anybody wishing to testify?
We do not, Chair.
Okay, I will now close the public testimony portion of this hearing. Commissioners, we're going to go ahead and move to a vote on this. I really was hopeful that we could get to yes on this particular situation, and I agree 100% with what Commissioner Scholl has said. I too have gone out to visit, but I'm confused on the applicant's initial wording, and they claim where they say they are not a church and they are not a religious organization, yet they want to use the RLUIPA federal statute in order to get them approval. Maybe they can go back and redo the application, and working with staff, can we find a way to get them to yes? I don't see it happening today. If Commissioner Savas was here, I think he would have maybe as equal amount of trouble getting to under goal exception 13, 14, and even 3. So I'm going to ask that question of Martha Fritzie. I'm putting you on the spot, Martha. If the applicants were to redo it and come back, and because commissioners, we're all faced with capacity issue in treating the people that this organization does. And the organization, it's a fairly long-term program of 9 months, which statistically showing the longer the program, the more success for these people for the long term. And we know it works. You know, I don't disagree with that. But the questions that are posed to us today, as Commissioner Fisher related, we were asked one certain question. So Martha, can you help me on this?
Well, I like to give very definitive answers, and I honestly can't in this case. So we have worked with the applicant for months and months, and we have tried to get there. But quite honestly, we don't know if this could meet the criteria for a goal exception. Right now, it doesn't. I can't tell you definitively if there's a way to get there or not. I am certainly all about problem solving and creative solutions, and I'm not sure if we can get there.
So maybe I'm not sure what the applicant's intent is. Maybe they want to appeal this. Totally fine. I have no problem with an appeal of this decision today. Maybe the applicant wants to come back and maybe work with staff, as I am hopeful that you would do, to see how they could get to yes with maybe a different type of application. I don't know if that's possible, but I'm just going to open the door to that. Commissioners, I'm going to accept a motion at, Mark, you have your hand up. Mark, you're on mute. Mark, you're on mute.
No, I just put it down.
I'm sorry, Chair. No, I was just ready to make a motion. That's all my hand was up for.
Commissioner Schrader?
No, I didn't. I just put my hand down.
Oh, okay. Commissioner Scholl, state your motion.
Chair Smith, I move we continue this matter until 3 or 10 February at 10 a.m. for a deliberation and decision only.
Do I hear a second? Going once, going twice. Your motion has failed for lack of a second. I will now entertain a motion from one of my commissioners.
Chair Smith? Would you like to go, Commissioner Schrader? I move we deny ZO208-21-CP is recommended by staff and the county's planning commission.
Do I hear a second?
I will second.
A motion has been made to deny applicants Z0208-21CP as recommended by staff and by Commissioner Fisher, and has been seconded by Commissioner Schrader. Is there any further discussion on this item from my commissioners? Hearing none, Shannon, please call the poll.
Commissioner Scholl,
No.
Commissioner Schrader,
Aye.
Commissioner Fisher,
Aye.
Chair Smith.
Aye, motion passes 3-1. Okay, Nate, what's up next?
So since the application's denied, go ahead and direct staff to draft findings to reflect this decision included on the board's agenda at a future business meeting.
Since this application has been denied, I will direct staff findings reflecting this decision and included on the agenda for this board's adoption at a future business meeting.
And we
Council,
will have those, yes, we'll have those findings ready to go. It'll appear on a consent agenda so you can approve the findings, review and approve, and ask any further questions you may have.
Okay, any further, before I close this hearing, are there any further comments anybody would like to make for commissioners or staff?
I just wanted to ask staff, they could appeal this decision, is that correct, to LUVA?
That's correct. This is a land use decision. So 21 days after the order and findings are adopted, that would be their window to appeal, correct?
Okay, Commissioner Scholl. Oh, I'm sorry, Martha.
So there is a process should they want to move forward with that. Okay, thank you.
Yes.
Commissioner Scholl.
Yes, Chair Smith, I would like to thank the people of the Northwest Bible Training Center for their hard work, for their efforts in trying to get this passed. And I would like them to stay positive and continue to work, however that might be, wherever that might be, to help the people of Clackamas County. Thank you very much.
I agree, Commissioner Scholl's sentiment on that. I would like to find a road to success for them. If it's through the appeal process, have at it. It's your legal right to do so. I will now close the public hearing. And if there's no further business before the committee, we are adjourned.